Hello, entrepreneurs. Welcome back. Stephen Jordan here, business law attorney who has practiced for 18 plus years exclusively in business law, which is inclusive of intellectual property and real estate, which encompasses mergers and acquisitions. I practiced with prominent large law firms for most of my career and also served as in-house counsel for successful business corporations. Represented small and large companies, closely held entities, all the way to publicly traded companies. Over the years, worked on thousands and thousands of transactions. Disclaimer, the content in this video and in all my videos is not legal advice, and it's for informational purposes. All right, that being said, let's talk about the topic of this video is buying and selling a business. So buying and selling a business, and let's talk about the elements in the stages in that process. Initially, there's a letter of intent, an LOI, letter of intent, and that entails a buyer identifying a seller, and there's specific terms identified subject to further negotiation as to what the definitive terms and definitive agreements are going to be, in addition to disclosure, due diligence of all the due diligence materials, which I'll talk about. After an LOI is signed, and even beforehand, you want to engage a lawyer to represent you, whether you're a buyer or seller. You do. There's too much at stake and too much at issue, and that can go wrong. You want an exclusive business attorney, not somebody that also handles other areas of law. You want a business law attorney that's experienced, and experienced also specifically in mergers and acquisitions, and that they've handled a number of them, and make sure that any attorney that you deal with has that level of experience, because there's a lot of stuff to be negotiated and played out. All right, so there's the due diligence period after the LOI is signed, and everything's going to be disclosed and opened up. There will be all the contracts of the company, the financials, the taxes, asset information, debt information, company obligations, and all the company's governing documents will be made available and opened up to the potential buyer. And let me back up. The letter of intent is non-binding to do the definitive deal. It will be binding as to confidentiality as to the company information that's going to be disclosed, and even the confidentiality as to this possible deal. Often the LOI also will have a non-shop provision, which says the seller can't shop this business to anybody else during a specific period until the parties figure out whether or not this deal is going to fly. So that being said, so during the due diligence period, and the buyer's looking at all this stuff, and sometimes a deal can blow up. They see something that they don't like, an environmental issue, tax obligations that are going to crop up, whatever they see, they don't like, the deal, it could snuff the deal. Also, during this period, the definitive documents are being negotiated and drafted between the attorney for the buyer and the seller. And there's a lot of documentation that is put together to transfer a business. Now, there are asset deals and equity deals. Most mergers and acquisitions are asset deals and not equity deals, because with an equity deal, I'm not saying that never happens. It happens a lot with equity deals, but most of them are asset deals. It's because buyers want to come in and they want to, if they have an equity deal, the buyer steps into the shoes of the seller. They become the seller in that company, whatever that company was. They buy the equity in that company, and there's a lot of risk inherited in that. And typically they say, no, any back stuff that you've done, we don't want to just inherit undisclosed things that you've done in the future. Instead, look, just sell us the assets, and we'll assume those and including contracts and stuff like that. And so we just want the assets. We don't want to step in your shoes of the company and buy your stock or your membership interest in an LLC. So those things are negotiated, and there's a lot of ground to negotiate, which is why you definitely want a seasoned mergers acquisitions business lawyer to represent you on either side. If I'm representing a buyer, my hat is very different than when I'm representing a seller, because with a seller, I want to help the seller minimize future obligations. They want to get cash all up now with as little risk going forward as possible. And the flip side is true with the buyer. I want all these reps and warranties as to everything is such and such a case, and even possible recourse and indemnities from the seller should any of those reps and warranties that I'm asking for prove to be untrue. So the hat that I wear, and it depends in an M&A deal who I'm representing. And M&A business law attorneys that do this stuff, they know usually the room that what they can get away with, as whether they're representing the buyer or the seller, and how far to push. And because they know what the norm is, they know floors and ceilings on what they can get away with. And when you have a lawyer on the other side that hasn't done a fair bit of M&A work or isn't a business law attorney, they get pushed over. They don't even realize it. They're getting paid in the deal, whatever that arrangement is, but they don't know what they're doing, and I can get away with the sun and the moon. It's just the way it works. It depends on who you're representing. Lawyers are paid to and have a obligation to zealously represent their clients. So that's what they do. So in any M&A or a sale of a business, purchase of a business, there's a host of critical provisions and typical transaction documents that are incorporated into those. I'm not going to go through all those. We could spend on each one of them an entire video. But let me just say there's some really key bullet points that I'm going to hit on here. Critical provisions that should be considered. Indemnity. Indemnity is a big key. Those that aren't experienced, lawyers that aren't experienced about indemnity in an M&A transaction, they're not going to know what they're doing. But it can either be a huge exposure or not enough security, depending on which side of the table you're on. If it's what's not, it has to be negotiated fully to the advantage of whichever side of the coin you're on. So indemnity is key. Non-competition provisions in the scope of the non-competes are key, and who is providing the non-compete is key. Which employees, which directors, which officers, and all those kind of things. Confidentiality, who's also tied in the similar respects. Debts and contract disclosures. And the representations and warranties as to asset and condition of assets and the scope of the assets, in addition to the extent of the debts and obligations and risks, the extent of those warranties that are provided. And that is usually hugely negotiated and a big part of the deal. And it's often overlooked by buyers and sellers, but the lawyers that do this stuff get it. You want the sellers to be able to sleep at night if you're representing them, and the buyers, you want to make sure you got the sun and the moon for reps and warranties, because if they said the income was X over a certain period of time and that's what you're banking on going forward, and that's why you paid the purchase price that you did, you want to build in reps and warranties as to income, and you don't want undisclosed risks and obligations to rear their head and the seller not be on the hook. You need that. So those are the big things that are always at play. Assumable company contracts is a big one that has to be considered all the time. Is consent required to transfer on any contracts? You got a lease, is it transferable? You got a software license, is it transferable? Do you need consent first? Can they get consent? All these things are always big issues, and you need to deal with them. So very important. Sellers post-closing obligations, and even possible often employment terms. Is the seller expected to stay on, and what are the terms of that seller's employment? Um, and so those are often critical, as to other key employees agreement terms. Um, so there also may be other things. Are they transferable that you really got to look at? For example, I don't know, is there a liquor license for a business? Is that an issue? Is that transferable? So a state issued license, is that transferable? So anyway, a lot at stake with buying and selling a business. Engage a seasoned business law attorney that does and has done a lot of mergers acquisition work. I highly recommend you to do that. And it's hard to cover a ton in these videos because, and that's why I'm trying to post a lot of different ones, so you can decide the issues that you really got to look at for yourself. What I can offer is I offer a comprehensive business guide, which is $19.99. You can email me and I can give you more information on that. But it has a lot of helpful information, whether you have an existing business or starting a new one. That's for $19.99. Also, I offer my business consulting services. Feel free to email me. Happy to provide more information. But for other attorneys doing the work that I do, I'm telling you, I'm offering my rate at a fraction, about a fifth of what other large firm, seasoned business lawyers are going to charge you. So email me, happy to assist, and even give you an idea and how I can help. I have 18 plus years experience exclusively as a business law attorney. Please check out my other videos, and in particular, am I paying too much for my legal representation? Take a look at that video too. So hopefully it was helpful. This is Stephen Jordan. Well, let me back up. Thank you for tuning in. Let me say that. And look at my other videos. Any questions or comments at all, email me at stephenjordanesq@gmail.com. stephenjordanesq@gmail.com. Stephen Jordan, Stephen Jordan, both the same. Wishing all of you prodigious business success. Have a wonderful day. Until the next video. See you.